Excited Utterance, the Evidence and Proof Podcast. Episode 156, Nila Bala, the Parent-Child Privilege as Resistance. Welcome to Excited Utterance. I'm your host, Alex Nunn, from the Texas A&M University School of Law. Excited Utterance is your podcast for cutting-edge scholarship and developments in the world of evidence and proof. We bring virtual workshops to you throughout the academic year. Joining me on Excited Utterance today is Nila Bala, an acting professor of law at the UC Davis School of Law. As you're just about to hear, Nila and I discuss her most recent paper entitled The Parent-Child Privilege as Resistance, which is forthcoming in the Boston College Law Review. The parent-child privilege is not codified in Rule 501, of course, nor is it recognized in federal law. But many states do recognize an evidentiary privilege for communications between parents and children. You're going to hear Nila talk about this privilege, emphasizing how important it is, not only for protecting parent-child relationships, but also for resisting injustices in our legal system. I really love this paper from Nila. I think it's hugely important, both for doctrinally understanding a new area of privileges law, and as well for the normative reform it could bring to the field. So I hope you enjoy my conversation with Nila today. Nila, welcome to Excited Utterance.
Thank you so much for having me. I'm really excited to be here.
Well, today we're talking about evidentiary privileges, and this is kind of like a core topic in evidence law. I think many of our listeners will, of course, be familiar with privileges, but some, of course, might not. So I want to begin the interview actually with just a basic question. So Nila, remind us, what exactly is a privilege?
Sure. So a privilege is a legal rule, an evidence rule that protects communications within a certain relationship from compelled disclosure in a court proceeding. And you've probably heard of some of these privileges, right? So there's attorney-client privilege, spousal, physician-patient, psychotherapist-patient. And essentially what privilege does is provide a special status to these communications. I'll also highlight two other things that are interesting about privilege. One is most other evidence rules, it's a worry about quality or reliability of evidence that creates the rule. But with privilege, that's not the case. With privilege, it's not that the evidence isn't relevant or reliable, but that we believe that there's this interest that's more important than revealing the truth, the interest in the relationship. And because of that, we tend to want to limit the number of privileges we have because that evidence is actually fairly good evidence. And then the second thing I'll mention is that the federal rules of evidence do not actually list all the privileges I mentioned earlier. So the proposed federal evidentiary rule for privilege was actually among one of the most contentious. The advisory committee initially did propose a list of privileges, but Congress instead passed Rule 501, which actually delegates to courts the decision of which privileges to recognize under common law. So courts get to create these privileges in light of reason and experience. That language is from Rule 501. And states, of course, can create their own privileges as well.
So, Nila, your paper advocates in favor of a parent-child privilege, and I think that's hugely important. A great idea. I think it's just as important as many of the privileges that we currently have recognized in evidence law. So why doesn't that parent-child privilege already exist in many jurisdictions?
Right. So first of all, I should mention that there are 6 states that recognize some version of a parent-child privilege. But you're right, most jurisdictions don't. And I think there's a few reasons for that. First is remember how I talked about this original list of privileges that the advisory committee did propose? So there were these original 13 privileges proposed by the advisory committee. And even though those privileges were not actually passed into law, the list of those proposed privileges is what legendary evidence scholar Professor M. Winkler-Reed calls one of the most influential pieces of legislation never enacted. So the proposed privileges, even though they were rejected texts, they came to guide the privileges recognized by federal and state courts. And so parent-child privilege, not on that list. And why wasn't it on that list? I think part of the reason has to do with the lack of children's lobbying power. So when Dean Wigmore was reflecting on the privileges that exist, he argued that the most successful legislation for privileges was made by these organized occupational groups that believed they had these special interests, and so a privilege was necessary. And unfortunately, in this country, we have never developed an ongoing and effective political constituency for children. So it makes sense when we reflect on that federal courts and the 44 states that don't have a parent-child privilege have continued not to have one. And then I'll also say, Alex, that there's this history of children's status in society that I talk about in the paper. So if we go way back in history, children played lots of roles similar to adults, including serving on juries, being able to enter into contracts, being in the military. But around the 17th century, we see a change. And we see the origin of the rule that children should not testify. And so, like wives, the idea is that children are subsumed into one legal person under the patriarch of the family. And this is also known as the doctrine of coverture. And if you put all these principles together, it means allowing a wife's testimony or a child's testimony could essentially amount to forced self-incrimination, since they're essentially one and the same person as the patriarch. So there might be a link there that I explore in the paper between child coverture and this lack of parent-child privilege, at least with respect to the minor's testimony.
Well, Nila, I have to say first, I think that we all agree with you that Professor Adam Winkle-Reed is indeed legendary. That's an apt word for him. But I also want to explore the fact that your paper, it wants to change the status quo, and it does present a very effective argument on that front. So first, you offer instrumentalist reasons for recognizing the parent-child privilege. Walk us through some of those.
Sure. So just to take a step back, what is the instrumental rationale, or what does that mean? So instrumental, or maybe utilitarian would be another word for it, is this idea that we should only recognize privileges if it's an essential instrument or some kind of means of protecting an important social relationship. So going back to Wigmore kind of created this four-factor test to argue for the creation of certain privileges, and that they essentially had to survive this cost-benefit analysis, that the greater good of the privilege would outweigh any negative consequences. And Wigmore focused on if the communication originated in confidence and whether it was that confidentiality was essential to a full maintenance of the relationship, and whether the relationship is one that we want to foster. And so I'll say there's been a lot of criticism of instrumental rationales for privilege, because when we ask people about whether they understand privilege, most people don't. Most people don't understand formal evidentiary privilege when they form their relationships, even professional ones like attorney-client or doctor-patient. And the other criticism of the instrumental rationale is that even if they knew about the privilege, would it really shift their behavior in the relationship? And it seems like even if they knew that there were exceptions, they would probably still form the relationship because they really need that relationship. So there's this argument that there's really no harm to a lack of privilege, since these instrumental rationales may not survive. And the assumption that privilege is necessary then would be a false one. So while I do think there's a lot of truth to this critique in general, I do question this in two ways with respect to the parent-child privilege. So I think it's generally true that parents and children, like spouses, are often unaware of the lack of privilege, but I don't think that's true once they enter the justice context. So at the point of court involvement, the lack of privilege is more obvious because the child's attorney will likely advise the child client not to discuss their case with parents, and often will not include parents in client discussions, partly because of the lack of privilege. I noticed this when I was a juvenile public defender. We'd often try to talk to our client outside of the parent's earshot. And that's because of the lack of privilege, among other factors. At the same time, I question the fact that the legal system is relying on parents in both formal and informal ways while simultaneously denying this confidentiality or this protection to those conversations. One example I provide is the legality of police interrogations of minors. So custodial interrogation, you normally give the Miranda waiver and then you can proceed. And in many jurisdictions, a parent is required to have a meaningful conversation with the minor. And then when you think about it and you realize that those conversations are not protected by privilege, the parents can be subpoenaed, it can really undermine the benefits these conversations could have. And I argue it's absurd to both require parent-child conversations, as some jurisdictions do, and then deny any legal protection for those communications.
I think those are great arguments. And complementing those instrumentalist arguments in your paper, you also have non instrumental, or some might call these humanistic justifications for enshrining a parent child privilege. So, if you would, Nilla, walk us through those.
Yeah, I think these are actually the strongest arguments for a parent-child privilege. And what I mean by non-instrumentalist or humanistic, an approach like this would suggest that the confidentiality of the communication matters as an end in and of itself. So a non-instrumental reason for privilege is to protect privacy within that relationship. And I talk about a specific kind of privacy here, what I call relational privacy. And while there are certainly domains and activities that we wish complete individual privacy for, where we really don't want anyone to know about what's happening, I argue that much of our lives are richer through sharing it with people that we love. And a lot of development for young people happens in relationship to others. So, this relational privacy is increasingly relevant in the digital age where we often do kind of co create selves or share ourselves through these networks. And it's less productive to focus on the fact that information was disclosed to a third party, in this case, to our parent. So I argue that we should see these privacy related behaviors as embedded in a certain context, in a certain relationship. And that this strong parent child relationship where we have some privilege could mean that children and adolescents are actually more willing to disclose information about their lives to parents, which, of course, those of us who are parents would love. But also, social science research suggests that it's a really important thing. It's a really important source for parents' knowledge of their children's lives. It's actually the strongest negative predictor for adolescent risk behaviors to have that strong parent-child relationship with communication. And that relationship is so important. And I think a parent-child privilege would recognize that.
Well, I think your paper is just so amazing, particularly because it kind of goes beyond simply proposing the privilege and also considers what the broader implications of a parent child privilege would be. And specifically, Nilla, you argue that a parent child privilege can serve, in some ways, as a form of resistance against unjust systems. So, if you would, build out that important claim for us.
Sure. So, as I mentioned at the outset, privileges are generally disfavored. The idea is that we're keeping evidence from the decision maker, from juries. We want to limit that. So, current privilege scholarship essentially assumes a faith in the adversarial legal system, in that interest in soliciting, collecting, admitting all available evidence. And I argue that this assumption implicitly accepts that first, the adversarial system is valid, and second, that the substantive law that privilege limits is also valid. But if we question the legitimacy of the adversarial system and the law it upholds, then the cost benefit analysis of adopting a privilege might shift. I'll briefly say here that I look at parent child privilege in this larger historic context of a country that has marginalized Black and Indigenous individuals by systematically destroying privacy within the parent child relationship, taking children away from their parents. And so, in some ways, privilege is that resistance. It's a countermeasure, a step in that respect. And part of my impetus for thinking of privilege in this way also reflects the way other countries have reacted against totalitarian governments that, again, encouraged or even required parents and children to testify against each other. I'm thinking of communist China, Nazi Germany, the Soviet Union here. And so I'm thinking of privilege as a form of resistance to seek relief from a state that might be prioritizing unjust laws over these really important relationships.
It is such an important point, such an important observation. I think that this is why I find your article such a promising and hopeful vehicle for reform for combating those injustices. And Nilla, you note in particular that a parent-child privilege, as we think about resistance against these injustices that you mentioned, it could serve as a vehicle for reform in healthcare. So let's focus there first. How could the parent-child privilege bring us reform, fight back against these injustices in the healthcare system?
So that's one of the reasons I found writing this article so exciting, because I was really reflecting on this post-ops time and how privilege as a form of resistance could respond to the post-ops world. So I noticed reproductive rights were under threat, same with gender affirming care, and minors' abilities to access these forms of care are especially under threat. So young people are confronting major hurdles to accessing healthcare. I also saw in my research that most people have historically involved a parent before seeking an abortion, before seeking gender affirming care. And in addition, parental support is essential for transgender and gender nonconforming youth. It's a key protective factor in preventing depression, anxiety, suicide. Yet again, there's no widely recognized parent-child privilege to protect kids when they go to their parents seeking this care. So conversations around reproductive access, gender affirming care, these have all been traditionally tough conversations to have with a parent, but now they carry a greater risk of generating evidence and creating criminal or civil liability because of the Dobbs decision. And we're already seeing that. We're already seeing the first court cases using parent-child communication to prosecute parents and pregnant minors for abortion-related crimes. So I think parent-child privilege is a reasonable response to these sorts of cases.
Absolutely. I think it's hugely important. And I'm curious because it could bring so much reform to the healthcare system. Any other areas where you see a parent-child privilege bringing normatively desirable reform or change to an area?
Absolutely. I also talk about the juvenile legal system, or for that matter, the criminal legal system, both of which have utterly failed our children. So, children in these systems are experiencing high rates of trauma, high rates of reoffending. They're separated from their communities. They're often shipped very far away. They're incarcerated. They're not rehabilitated in any meaningful way, even though this juvenile legal system was created to do that. And system involvement, we've seen, leads to these permanent effects to educational outcomes, employment outcomes. I'll say that children transferred to the adult system fare even worse. So they face high risks of trauma, sexual abuse, physical abuse, suicide. So overall, we're seeing harsh, punitive sentences that disproportionately affect Black and Brown youth. In some, the system's not working. And many are calling for significant changes, whether it's a reorientation of services or abolition of the system entirely. What seems to work best for kids is a restorative model. It's one that incorporates families, and it's one that I see privilege being a part of. And parent involvement is generally indispensable to the rehabilitative mission of the juvenile court. Excluding parents, telling them to stand outside, not including them in conversations, it's generally not what children want either. They often go to their parents, privilege or not, to seek guidance. I think that abolitionists obviously would be sympathetic to using privilege as resistance to oppose an unjust juvenile legal system. But I also see this as an argument that libertarians and conservatives would be able to get on board, folks that want to generally minimize the impact of an unjust criminal legal system and of a system that's interfering within the family system and the benefits that the family system can bring.
Well, I have to say, I'm convinced. I am completely on board. You've convinced me that we absolutely need this parent-child privilege. And I can't say that for every paper that comes on the show, so I've loved engaging with this. What I'm interested in now, though, that I'm on board with the broader project, are the details. So how would the parent-child privilege actually operate? So first, Nila, what are your thoughts on how broad the scope of a parent-child privilege might be?
So there's definitely a number of factors to consider in crafting this privilege. And some of the things we need to figure out are who the privilege covers, when it starts. One of the things I do is I look at the 6 states that do have a privilege and what they're currently doing. And so these are Connecticut, Washington, Massachusetts, New York, Idaho, and Minnesota. And I get into detail in this in my paper, but I do try to strike a fairly pragmatic approach. There's certainly a very expansive vision of privilege. In fact, there's at least 4 permutations of this parent-child privilege, depending on which direction it's going, parent to child to parent, and also whether it's protecting an adult offspring or a minor child. And I think there's really good reasons you might want to protect the child from having to testify against their parents, but I consider what I call the essential parent-child privilege, which is that privilege that would protect the minor when they're trying to get counsel from their parent, advice from their parent. And that's where I start. I start with a privilege that prevents the parent from testifying against the minor child, thus protecting that minor's ability to go to their parents for that advice and guidance. I also advocate for a privilege that starts before a young person is taken into custody. For example, Connecticut has a privilege that only starts at that point. But I believe that minors might need the most help deciding what to do before legal system involvement. So we really want a privilege that starts before arrest.
And let me follow up for a second on an area that I want to kind of get clarification on. How are you approaching the definition of a parent for the purposes of the privilege? What does that term encompass?
Yeah. So again, I was kind of looking through that lens of privilege as resistance. And I think it guides us to tackle two pieces of who is defined as a parent. The first is looking at families that have been denied privacy historically and the narrow definition of parent, who that leaves out. And second, it's by looking at privacy for children who are a ward of the state. So I'll take the first piece first. So, what family and what a parent looks like has definitely changed throughout history. And I say that a parent child privilege should ensure that it covers de facto or functional parents. This is the term of art for parents who may not be the biological parent, but they really are that primary caregiver to the child. They're the person the child is turning to for advice, and they're recognized by the court in that way for other purposes. So I'm saying parent child privilege, we should also recognize that person as the parent in this realm. So I also explore the scenario where the child is the ward of the state. And the state is playing a really interesting role here. They may be acting in the role of the parent in some regard, but they're also a prosecutor. They're an adversary in court. And children who are in the system, they experience surveillance and scrutiny. The state is going to amass meticulous records, often for liability purposes, on all their communications they have with the child. So they're not going to have those typical conversations between a parent and a child that might get fuzzy over time, subject to memory. For children of the state, I mean, the child's own statements are creating these documentary records, and they can be used against the child. And I argue that perhaps privilege might be able to help with this, maybe shielding those exchanges from state intrusion where the state is acting really as a parent, as parens patriae grants.
So, those of us who study evidence law will know that even if we have an evidence rule, we have to watch out because there are likely some exceptions that might be on the way or exceptions that are indeed operative in a particular jurisdiction. So, I'm curious, when, if ever, do you think that there should be an exception to the parent child privilege?
Right. So there have to be some exceptions, again, being pragmatic here, right, to protect the parent and the child. And I think the main reason, and again, I saw this when I was looking at the states that have privilege, the main reason you might pierce privilege is allegations of abuse or neglect. And I do question some of these exceptions because I think they're overbroad, given the increasing evidence that the family regulation system, AKA the child welfare system, is really failing in its mission, similar to some of the failures of the juvenile legal system that I note above. So I do think you need an exception for interfamilial violence to allow parties to testify, but I do question that neglect is so broadly defined right now that, in fact, even some of the states with strong libertarian and conservative leanings have been the leaders in narrowing definitions of child neglect, because otherwise some of these exceptions will start to swallow the rule. So I do think we have to look at the allegations of abuse and neglect as maybe potentially overbroad. And then two other things I think we should reconsider. One exception has to do with civil context. So there are two states that currently have parent-child privilege. They exclude civil context completely. And I believe that the privilege should cover criminal and civil systems, especially because civil cases can have just as grave consequences as criminal cases. So I think this is sort of a symptom of a larger problem with criminal law exceptionalism. And then finally, if we are going to have any sort of crime fraud exception, which means an exercise of privilege would be an exception if a crime is suspected, we want to make sure that crime fraud exception does not eviscerate these protections we're trying to create for children accessing reproductive and gender affirming healthcare access.
I feel like I could hear you talk about this paper, engage with this idea for hours, but unfortunately, we're a little pressed for time. So I only have one final question for you. Nila, what's next for the literature? What type of paper might shed additional insight on this issue?
Yeah. Well, I mean, one thing I really hope for is I hope this piece fits into this larger scholarship that's currently occurring that's critiquing traditional evidence law. So, traditionally, evidence law has been understood as the set of neutral rules, these neutral principles, and that there's rational reasoning by a neutral legal decision maker. And so, I'm hoping this fits into this larger project. And I'm actually working on transforming this paper into a book chapter that'll be part of this book called Critical Evidence. So soon to hit a shelf near you. and it's being edited by Bennett Capers, Julia Simon Kerr, and Jasmine Harris. So excited about that. And then other things I think we could do. I think it'd be fascinating if scholarship could explore how the parent-child privilege in the 6 states that have one, how does it actually affect juvenile proceedings in those states? I don't think there's been very much research on that. And then finally, for me, I'm constantly thinking about that parent-child relationship, how it affects privacy, how technology is changing things. So that's where my personal scholarship is likely to go in the future.
Well, I have to say, I can't wait for that book on critical evidence theory because that is a collection of superstars if I've ever heard one. Bennett Capers, Jasmine Harris, Julia Simon Kerr, and of course, Nila Bala. I think that's as good of a lineup, and I'm sure there are many more joining you. So thank you, Nila, so much for coming on Excited Utterance. I love this idea, and I can't wait to see your work in the future.
Oh, thank you. Thanks for having me. This was a blast.
At least in theory, privileges constitutes an area of our evidentiary regime where evidence law's historic common law development is supposed to continue apace. Of course, when the federal rules of evidence were codified in 1975, the House and the Senate rejected a proposal from the Advisory Committee to the Federal Rules of Evidence to actually codify certain discrete privileges. Instead, what the House and the Senate decided to do was to codify a flexible rule that would give courts room to, yes, continue to apply privileges that were recognized at common law, but also develop new privileges, privileges that evolve to meet the contours of an ever-changing society. Now, of course, has it worked out that way? Have courts been proactive in continuing to recognize new privileges at the federal level? Not at all. In fact, if you actually look at what privileges are recognized in federal law, they largely mirror those that were going to be codified under those rejected rules. But even though descriptively it might be the case that federal privileges law is somewhat limited, normatively, that's not necessarily desirable. As I just mentioned, society is always evolving. Our understanding of the world around us is changing. Scientifically, it's improving. Culturally, we have different, perhaps, values than we had in the past. And Rule 501 is flexible enough to allow courts, to allow judges to contour privileges to meet that evolving society. I therefore think that Nila's paper is hugely important, not only because it recognizes this highly important relationship, this value relationship between parents and children, but also because it constitutes an important inroad, one that we can all get behind in developing a new privilege, recognizing it at federal law, and hopefully kickstarting evidence law and its substantive evolution. So, needless to say, I am a huge fan of Nila's paper. Nila is very much a rising star in the evidence world, so I was so happy that I was able to chat with her, and I hope you enjoyed my conversation with Nila today. Support for Excited Utterance is generously provided by Vanderbilt Law School's Branstetter Litigation and Dispute Resolution Program, as well as the Texas A&M University School of Law. The producer is Ed Chang, and the production editor is Anirudh Barella. Additional assistance was provided by Lexi Whitaker, and background music is provided by Kirsten Castle-Greer, Felix Wong, and Alex Crew. I'm your host, Alex Nunn, and I hope you'll join me next time as we explore another piece in the world of evidence and proof.